didn't see him join the meeting.
Okay, he may not be here, right? Joel.
Hi, Joel Camburn, public board member.
Brian.
Brian Thomas, CPA member.
Jackie.
Hi, Jackie Mayucci, CPA board member.
Kate.
Good morning, Kate Dixon, public board member.
Carol.
Good morning, Carol Morgan, CPA board member.
Tom.
Hi, I'm Tom Sawatsky, a CPA board member in Walla Walla, and it's going to be 100 plus again here today.
Ooh. And Brooke, our newest board member.
Good morning, Brooke Stegmeyer, CPA board member.
Thank you, everyone. Now I'd like to introduce board staff. So board staff unmute their mics. Charles.
Charles Sally, Executive Director. And I just want to note I'm having some construction done today, so at various points there may be some noise in the background.
Okay. Jen.
Good morning, Jennifer Skiba, Deputy Director.
Thank you. Kirsten.
Good morning, Kirsten Donovan, Board Clerk.
Okay. Taylor.
Taylor Shahan, Lead Investigator.
Tia.
Tia Landry, Data and Systems Administrator, and I'm running the meeting, or trying to, hopefully.
She's our technology overlord today.
Yes.
Is anyone else any more other board staff here? I didn't see anyone. Okay. Thank you very much. Now I'd like to give an opportunity for guests to introduce themselves. So if you would like to, you don't have to introduce yourself, but if you'd like to unmute your microphone and state your name and who you're with, that would be great.
Tom Neal, Finney Neal and Company, former board member.
Julie Phipps, Manager of Practice Quality at the Washington Society of CPAs.
Norm Paulson, CPA in Camas, Washington.
Jeremy Saladino with the Washington Association of Accounting and Tax Professionals.
Scott Wolfley with the Washington State Auditor's Office.
Kimberly Scott with the Washington Society of CPAs.
Ashley Kittrell with the Washington Society of CPAs.
Ken Smith with the School Accountability Group.
Anyone else?
Bruce Turcott, Assistant Attorney General Board Advisor.
Michelle Carr, Assistant Attorney General, Incoming Board Advisor.
Excellent. Okay, well, thank you, everyone. You did an awesome job. That was very orderly, right? I think you did a great job, so thank you. Thank you very much. So that, as far as we've gone through the introductions, so we are actually going to move to a public rules hearing on three proposed rules. So it's 9:09. So I guess I temporarily close the board meeting at 9:09 and open the rules hearing at 9:09. The Board Accountancy Rules hearing is now in session. The date is Friday, July 31st, 2020. The time is 9:09. My name is Mark Hugh. I am Chair of the Board of Accountancy. Copies of the rule proposals are available in the board packet and online at the board's website. If you'd like to testify and no one identified that they in advance that they want to testify, please let me know, and your participation in the hearing will be added to the rules hearing roster. No one identified earlier. Would anyone like to change your mind and testify? Okay, thank you. So the hearing will be conducted as follows. I'll identify the rules presented and present a brief statement for each proposal. Normally I'd use the attendance roster to invite testimony on the proposal, but no one has chosen to testify, and a brief statement for each proposal. when we are done discussing these proposals, I'll give one more opportunity for anyone to testify. We'll discuss the meetings in the board meeting today. We have 3 rule proposals. WAC 4-30080, how do I apply for initial CPA license? WAC 4-30-100, what are the rules governing reciprocity for accountants from foreign countries? WAC 4-30-102, how do I apply for initial Washington State license and foreign reciprocity? A brief statement on each proposal. Charles, feel free to jump in here. On WAC 4-30080, how do I apply for initial CPA license? We are eliminating a requirement in the rule for a CPA to take a board-approved Washington-specific ethics exam. This has existed for a number of years. It's difficult to administer. It generates bad will for us among licensees, and honestly is fairly redundant because as soon as people get licensed, they have to take Washington ethics as well. So we're moving to eliminate this requirement in the rule for licensing. And Charles, do you have any further comment on that?
No, Mark, that's very complete. I don't have anything to add to that. It's just, I will say that the exam was well intentioned. It just has been difficult for the staff to administer, and we have replaced it with an information sheet about the rules that people are supposed to read and check off. So that's, I think, a good solution to this.
Yes, thank you, Charles. Yeah, it was really with the very best of intentions. The idea to make sure Washington licensees are familiar with Washington laws and rules, but they have to get that anyway in their first licensing cycle, and it is incredibly difficult to administer and consumes an inordinate amount of staff time. There's 2 other rules that are related, the rules governing reciprocity for accounts from foreign countries and how to apply through initial Washington license or foreign reciprocity. In this, we are bringing some information that was into board policy into board rules, and making it more clear that we adopt a kind of I can't remember the name of the exam. The AICPA has an exam that basically tests foreign applicants for their familiarity with U.S. CPA rules. Charles, would you think that's an accurate description?
Yes, I don't have too much to add. It's just that we're in all 3 of the rules, we're changing the title format to getting away from the question format. Rules 100 and 102, as we had also reorganized the CPE rules, these are reorganized. Some stuff was formerly in 100 as we moved to 102 to kind of make it flow a little better. And I think they just clarify the requirements for people trying to get a license under foreign reciprocity. I think it's pretty straightforward. That's all I have to say.
Okay, thank you, Charles. Okay, so the rule proposals have been identified. Again, I assume no one wants to testify. If now, speak up. No one else wishes to testify. Thank you, everyone. The board will deliberate on the oral and written testimony and the proposed rules later today in a moment during this regular board meeting. The board's decision regarding the proposed rules will be posted to the board's rulemaking section of the website and reflected in the meeting minutes. Thank you, everyone, for your participation. The time is 9:14 and the hearing is now closed. So we have closed the rules hearing. We're going to reopen the regular meeting of the board. And so it's time for the board to consider those rules. And we'll consider them, the first one separately from the other 2. The latter 2 are linked. I guess if anyone on the board has any comment about that first rule, removing that requirement for that Washington-only ethics exam. If no one has any comment there, then I would like to get a motion. And your options are to adopt the rule as proposed, or adopt the rule with minor changes, which we have none, that do not change the general subject matter, amend the rule, or withdraw the rule proposal. So I would like to get a motion potentially to adopt the rule as proposed.
Motion to adopt the rule as proposed.
Thank you. And a second?
Second.
Excellent, thank you. Any discussion? Okay, all in favor? Aye.
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 Aye. Aye.
Anyone opposed? Thank you. Anyone opposed? Anyone abstain? Okay, the motion carries. Now we have to vote on an effective date for the rule. And the motion would be to make the rule effective 31 days after filing, January 1st, 2021, or another date. In the outline, it says the executive director recommends making the rule effective January 1st, 2021. And I had a question about that. I was kind of wondering why we're making this effective January 1, 2021 rather than sooner, since it's a test that no one likes to take. We don't, and it's difficult to administer.
Mark, as you recall, I'm working with NASBA right now to get the video in place of the exam.
Okay.
So unfortunately, with everything with COVID, and NASBA's been kind of taking time. They've been having people furloughed and stuff.
Okay.
So I'm working with them getting the video. I should have that done in a couple months.
Okay,
So
thank you.
we're waiting to kind of trickle up out, and we'll start it January 1st.
Okay, thanks. And Jen, your microphone, it's about every 2 minutes it sounds like you're in the jet stream. So, but thank you. We're replacing this with kind of a short informational video, more on kind of like the administrative things a CPA really needs to know to stay out of trouble. And NASB is creating a video for us, and so this will be replaced. So January 1st, 2021 is fine. So I'd like to have a motion and I think the motion would be to make the rule effective January 1st, 2021.
So moved.
Second.
Thank you. Any discussion? All in favor?
Aye.
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 Aye. Aye.
Anyone opposed? Anyone abstain? The motion carries. Thank you, everyone. The second set of rules on the foreign reciprocity, as we discussed, these are bringing some information from board policy essentially into existing rules. So I'd like a motion to, if there's any discussion, I don't want to short circuit any discussion on these rules before I ask for a motion. Okay, thank you. So I'd like a motion to adopt the rules as proposed, or adopt the rules with minor changes that do not change the general subject matter of the proposed rule, or amend the rule proposals and set another hearing date, or withdraw the rule proposal. So those are your options for a motion.
This is Carol. I make the motion to adopt the rule as proposed.
Thank you.
Second.
Thank you. Any discussion? All in favor? Aye.
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 Can I suggest that when you make a motion or a second, that you state your name so that our board clerk can get the notes right in the minutes?
Thank you. Excellent. Thank you. And who seconded that then? So Carol, I think, did the...
Kate Dixon, second.
Okay, Kate, that's you. Okay. Thank you. All right. So, I can't remember if I said anyone opposed. I can't remember if I said anyone abstained, but the motion carries. As far as the effective date, the staff recommends the rule is effective in 31 days. We have options for motion to make it effective 31 days after filing, January 1st, 2021, or another date. And so if I could have a motion, and if you could state your name.
Tom Sawatsky moved to make it effective within 31 days. After 31 days, sorry.
This is Carol. I'll second it.
Thank you. All right. Any discussion? Okay. All in favor? Aye.
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 Anyone opposed? Anyone abstain? Okay, the motion carries. Thank you. Thank you, everyone, as well. So moving on our agenda to the minutes. The April 24th minutes are in the board packet. And if anyone has any comments about the minutes, so now is a chance to comment on those. And if not, we'll have a motion. Does anyone have any comments or adjustments to those minutes of those from the last meeting?
This is Tom Sawatsky. Just real quick, while I'm a dedicated public servant, I'm pretty sure I was not at the meeting until whatever time it says at night, 10:55. I think it was 10:55 a.m.
Okay.
Only comment I have.
Okay, thank you. We'll make that adjustment. Anything else? All right, so if that's I'd like a motion to approve the minutes as drafted.
This is Carol. I make a motion to approve the minutes as drafted with the small annotation.
Thank you.
This is Joel. I second.
Okay. Any more discussion? All in favor? Aye.
Aye.
Anyone opposed? Anyone abstain? The motion carries. Okay, thank you, everyone. So moving on, a NASBA update. Several things going on regarding NASBA. Just wanted to give everyone an update. First off, there is under this update, we have the AIC proposed revised interpretation on record requests. And this is the AICPA making a change to the AICPA Code of Conduct regarding record requests. And it's important when the AICPA makes a change to this, and it really depends what state you're in. There are about half the states in the country don't have their own Code of Conduct. They adopt the AICPA Code of Conduct. So when the AICPA makes a change to that, essentially they're changing the Code of Conduct in about 25 states. And that, the list, there's a memo with the list in the outline. And so those are typically a lot of these smaller population states. They rely heavily on the AICPA Code of Conduct. They rely heavily on the resources of NASBA. There's a second group of states, larger population states, that don't adopt the AICPA Code of Conduct. And there's a third group of states that we are in that kind of partially adopt the AICPA Code of Conduct. So we take the AICPA Code of Conduct and then we modify it. If we're silent on it and it's in the AICPA Code of Conduct, AICPA Code of Conduct is the applicable interpretation. But oftentimes we modify it. And so this rule revision is actually very consistent with our existing rule. So we don't need to make a change to this rule. But it's good to let everyone know because it's going to be a big deal at NASBA meetings because essentially this changes the AICPA Code of Conduct in half the Code of Conduct in about half the states. Tom, you're on the committee that made this change, and you said you had some background, so I'd like to recognize Tom Neal if you wanted to give some background on this.
I will do that. Good morning, all. I serve on the NASBA Professional Standards Committee or Ethics Committee. They changed the names, so I just use whichever's handy. We got this proposal from the AICPA, and on its face value, it was really just an attempt to make some corrections in a couple places regarding, what do we do when somebody makes a request for records, and how best to provide those, and initially I think there was some issues regarding how to best transmit those. And so the question came down to, well, if you've got a portal and you put the records out there on the portal, what does that do? Does that mean that you've provided them, or if you've made copies and have them sitting at the front desk, that type of thing. And so they made some modifications in the Code of Conduct in section paragraph .06 for one, and probably the big one is how you make those records available under paragraph .11, and that was the big pieces to this. And on its face value, it seemed pretty simple and pretty straightforward. And so it went to our committee at NASBA. We looked at it. We agreed that, hey, this is probably a good idea. And so what happens in the process on the NASBA side is once our committee takes a look at it, and we make recommendations to NASBA's Regulatory Response Committee, who's then tasked with drafting a letter to PEAK to address whether we think this should be addressed or not. We got the draft letter back, and of course, time causes all kinds of problems. I got to thinking about this, and if you think about this from the context of what CPAs, particularly in public practice, do. So if I get a request from a client as a small firm practitioner for records, I will either provide them electronically, I'll provide them hard copy, but more and more firms now are using their portal to allow client to have access to them, as well as maybe providing copies, put them at the front desk to be picked up, as it were. And the dilemma comes in this rule is it doesn't address, is that meeting the intent of the member having provided the records? So if I hang those out on a portal for the client or former client to access, but they don't access the records, and let's say they forget, it's how long are you required then to keep them out there? And if you did provide them for whatever the length of time was, and the idea was is maybe that 45 days is a good time window, does that meet the intent that you have provided them, even though the client may not have accessed them or come to your office to pick them up? And so this was one of those little gotchas that as our committee members then started looking at the draft letter that said, hey, this looks fine, everybody started stepping back and going, wait a minute, this potentially creates a conflict, not only with existing board rules around the country, but also that concept of have you provided, and then if so, does that alleviate you from having to provide them again when you get that next request? And so this one, while it appears fairly simple and straightforward, does have a bit of a gotcha in it that our committee is now looking at and trying to say, okay, now what do we do? And we haven't gotten to resolution yet. And of course, one of the things that I love about NASBA is that, the one hand doesn't necessarily know what the other hand is doing. So we don't know if the Regulatory Response Committee will just forward the letter forward to PEAK that says, yes, this looks good. But if it does, I think we will have an issue that state of Washington may need to be prepared to deal with. The other little end around on this mess as well is that if you've hung those records for that client or former client on a portal indefinitely, does that give you issues related to the AICPA Code of Conduct relative to the concept of hosting services? That's another section of the code. So this has got some interesting little layers in it. What I thought was just a straightforward, small onion actually got a little bigger. So I'll leave it there and leave it open for questions.
Thank you, Tom. Record requests are areas of explosive interaction between licensees and typically their former clients. And so every year we have complaints about record requests coming in. So the rules need to be very clear and very thorough to protect both the public from getting their records from passive-aggressive behavior by their ex-CPA, as well as to protect the licensees as well. So again, we tend to be more restrictive than the AICPA as far as requiring certain records be retained. Many states in the AICPA Code of Conduct lets licensees withhold records for outstanding fees. And part of this clarification is you have to give them their original records back regardless. If a record has to be returned, we don't let it be withheld for outstanding fees under our existing rules. In a way, it conforms the AICPA Code of Conduct a little bit more to our rule. But as Tom mentioned, because there's so many complaints involving this issue, sounds like there's more work to be done on some of the specific circumstances.
Yeah, and the idea here is just to make sure that you as board members have kind of a heads up on this weird and crazy world of records requests. So that's Thank you, Mark. That was a good kind of summary on that one.
Thank you. Anyone have any thoughts on that? Okay.
Mark Brian Thomas. I just have a question on the highlighted sections on 44 and 45. Is there any import, Tom, to the highlighting?
No, it was more that those were kind of the key changes. In paragraph 06, one of the words that got dropped in, which was initially, I think, where Pete was going with this, is the word being able to ship such records. Apparently, at the AICPA level, providing the records, mailing the records, but also being able to charge for the shipping was an issue, which is kind of beyond my tiny mind, but that's okay.
That sounds like passive aggressive behavior.
Oh, exactly. So they really did want to bake in the ability to charge for the shipping of those things, and so they baked that in. And then the other one is just that whole concept of shipping records and making them available and making etc. on paragraph 11. So I had just highlighted those as kind of some of the key areas that our committee had looked at. So that's all.
Okay, thank you.
Other questions on that? Next on the list is remote proctoring of the CPA exam. The NASBA, which usually is kind of exploring the idea for remote proctoring of the CPA exam, which means applicants could take the exam at home, obviously under the circumstances, which would obviously keep fees going to NASBA as well. NASBA kind of focuses a lot on its money issues. So they're starting to explore that and just throw out the idea. I don't think there's really much more to say on that, Charles, right now. Do you think?
Well, here's the thing. This is being rushed, I think, by NASBA and AICPA for the very reasons that you've indicated. They did call in a conference of all the phone conference for all the EDs to attend and kind of get a temperature of what might be happening, what might be the acceptance level among boards of accountancy. So that's the thing I'm supposed to ask everyone today, is to kind of weigh in on what they think about this. Now, the trouble is, AICPA had a very nice demonstration of what remote proctoring might look like, and there is some thoroughness in the process wherein, the person's environment is looked at, and to make sure there aren't notes or crib sheets or something. Their time away from the screen is monitored, and there is some close contact. And NASBA itself had a very nice set of slides on, what kind of the implications of the remote proctoring were. Unfortunately, neither one of those videos or the Outlook or sheets discussing the information were made available. They had some legal concerns about releasing that information. So I don't have a lot to say about it. I think most of the EDs did express concern about the added risk for cheating during this process. And if the CPA exam is moved to this sort of remote proctoring idea, it would be the first professional exam, high stakes professional exam moved towards remote proctoring. So I think it would be best to express some cautionary support for this. I think they can explore the idea further, and probably what's going to happen is this will be fleshed out and presented probably at the annual meeting coming up.
Thank you. I mean, it's going to be a remote world for a while, not for like 2 or 3 months. It's going to be a remote world for a long time. So we all need to rethink, I guess, our approach to things and become more comfortable with remote, like proctored CPA exams, as well as figure out what new safeguards need to be applied.
Can I add, this is Carol, several years ago, many years ago, when I took the certified fraud exam, I took it remotely, but I had to have a certified person with me who monitored me. So it was remotely done, but there was someone who attested that I took this in the correct manner, who was also certified. So I don't know if they could move to something like that, where you have a character, that would attest to the integrity of taking the exam as opposed to doing it alone and by yourself. So, you know, I would say I didn't have a problem with that, but then it would mean also there could be collusion between two people as to how they were taking the exam. So you're back to the integrity and the ethics of the person taking it. But I think we're going to have to realize that if education is moving that way, we also have to, you know, begin to identify ways of accommodating that as well.
Thank you.
This is Tom Sawatsky, kind of, I guess, in line with those comments. I'm a little concerned about moving too far to the leading edge of this, where, you know, in the old tech days we talked about being the bleeding edge. This is like maybe getting a little too far out front of this. And I just, having read yesterday's headlines about the Washington State Bar just waiving the bar exam, I was amazed by that. I just don't understand, you know, well, certainly we can make better accommodations. We can split people up in scheduling. You know, this is just really surprising to me that we'd be this far ahead of out front of this before the technology is really ready to make us feel comfortable with it.
Yeah, great thoughts. I mean, you know, certainly there's models out there. I mean, the professional licensing has been around for, you know, in many professions for 100 years, and there's been other things that affected it. So certainly there's other models, as Carol mentioned, that can be kind of explored to add some safeguards as well. But yeah, it's waiving it completely. That's I hadn't heard about that. That's pretty amazing.
This is Bruce Turcotte. I'm a bar examiner for Washington, and the bar exam is created by the National Council of Bar Examiners in Wisconsin, and created by them for the most part. But they've created a number of options. They've added 2 additional testing dates in September, so there are 3 possible testing dates for this summer. And they've also created, I think very reluctantly, reduced online bar exam, a remote bar exam. So maybe NASBA isn't the first to go this route, but the national bar exam that's going to be available online, if a state chooses to opt for that, will not be portable to other states like the results of the Uniform Bar Exam are. So it will not have that nationwide advantage. But there is experimentation going on under great pressure in the lawyer examination area as well.
Thank you. So it's, again, we'll be seeing probably more of this, it sounds like, on the at the NASBA annual meeting in November. Again, this is a huge money issue for NASBA, and so I'm sure that's why it's being rushed. Update on the CPA evolution. For everyone who attended the NASBA regional meeting, the CPA evolution was talked about. NASBA and the AICPA are moving forward with their model of kind of a core and testing in kind of 3 areas, you know, information technology, accounting and auditing, and tax. And I'm not probably stating those correctly as well. So there's some good presentations during that. They mentioned that we are one of the states that have to change our rules. That's what NASBA said. And I think that may actually just be the titles of some of our rules. But I don't have any more update on that. Charles, do you have any more update on the CPA evolution?
They are moving forward at a great speed with this, and there was a memo that came out that I can provide to everyone. I think they didn't receive it directly from NASBA. I think the big change may come in our rules around what qualifies a person to sit for the CPA exam. We may want to be a little more inclusive of some informational technology type of courses that people are taking, so they get roped into maybe fulfilling the business requirements or something like that. We'll see how it comes out in the wash and kind of what we need to do. And at this particular point, we don't have a completely clear picture of what that will be.
Okay, thank you. Any other comments on that from anyone on the board?
So this is Carol. I would say that the universities and colleges are, I'm seeing embracing this and already beginning to make adjustments to the curriculums that are being provided to students. The interesting part is, what are they calling? What are they titling these courses? So trying to make sure that as we look at the rules, that we are not prescriptive as to titles or of what that might look like, because that could change over time with different universities. So just understanding that we need to be maybe broader in what we're looking at around the information technology type of profession and environment of what they have. So that's all I would like to.
Thank you.
And this is Jennifer. Just a reminder to the board, when we look at all the education, we always look at course content. We don't necessarily look at where it came from, the accounting, the business. We look at the course content. Based on that, looking at reviewing the course, that's how we make the decision. So I think we have it right now. I was surprised to see that NASBA pointed us out as one of the ones that had to look at our rules, because I feel like our rules are very open to interpretation, and we do take part in that. So we'll wait and see what happens, though.
Thank you. Anyone else? Okay, with that, we'll move on to the next item, which is a presentation, which was actually going to be in last board meeting, but it's going to be it's been moved here on the disciplinary process, how the process works, hearings. One of the themes of this board meeting today is the acronym BAP, which is Brief Adjudicated Proceeding. This is a type of hearing we've had in our rules. We haven't done many of them. They're going to increase, as we'll kind of discuss later, and those hearings are going to be circulated around different board members. So we'll talk more as we go through this. We don't often have hearings, but it's good to know what the process is. But everyone over the next couple of years will be participating kind of as a hearing officer in these BAP hearings. So we'll have lots more information on that today. So take it away.
Okay, well, Bruce and I were going to make this presentation. I can kick it off, Bruce, and if the noise gets too loud here, you may have to be my understudy for the content that I was going to do. So anyway, this is just a brief presentation. I'm going to move through this rather quickly. This was a longer presentation in previous board meetings that we provided, and this is to just certainly to help orient our newest board member, Rose Stegmeyer, and kind of in what our process is. And we are going to, like I said, this will be rather quick. Can I have the next slide, please? Thanks, investigations and the adjudicated process. Next slide, please. Okay, so this is imbued in the Public Accountancy Act, or RCW 1804, makes very clear kind of what the essential mission of the board is. And that's that, persons who hold themselves out as licensees, certificate holders, conduct themselves in a competent, ethical, and professional manner. And people quite a long time ago realized that accounting information is very important to the well-being of an economy, and that bad accounting information is the devil incarnate, even without any bad intention on the part of producing bad accounting information. Next slide, please. So the two governing sections of our law are certainly Chapter 1804 RCW, the Public Accountancy Act, and the rules, Chapter 430 WAC, which the board produces, and we did some of that today, obviously, and that's our responsibility, or the board members, not the staff. Staff comes up with the ideas, drafts a lot of things, but the board members have to actually approve it, and they have a lot of say about what the content of the rules is. The board has sole jurisdiction. So when we're regarding the public accountancy profession in Washington State, person has an issue with anything the board has done, they have to exhaust all the administrative remedies available through the board process before they can appeal it to a higher court. But certainly even board orders, anything like that, can be appealed to Superior Court. We do not have any statute of limitations with respect to the Public Accountancy Act. And we can debate about whether that's good or bad. In some cases, that can be kind of troubling when we're dealing with a very old issue. We're trying to investigate it. And there are some other legal implications with that. Next slide, please. So who do we have authority over? Well, we have authority over CPAs, and we have authority over people who are licensed firms. And as you may have been on the board for a while, you know that we've changed our firm licensing requirements, that only those firms engaged in attest or compilation type of activity, including SARS 21 type work, do have to have a firm license. And also people that use the title inappropriately. We have jurisdiction over them. So if you're calling yourself a CPA or a CPA firm and you are not, you are under the authority of the board. Next slide, please. What is the etiology of a board complaint to the board? What causes disciplinary action? Certainly there's unprofessional conduct, people do the wrong thing, unlicensed practice, which does happen. We've recently had a case of that. Peer review deficiencies, although we try to really work with that in sort of a remediation way, and CPE deficiencies, which we will have a little report on today about kind of how we decided to deal with that in an easier manner. Next slide, please. Complaints and investigations, and I will complete this section if Bruce is able to. He will take on from there to get on to this section. So next slide, please. And we can make these available to anybody here so you can take a look at them. I'm kind of going through this at a machine gun rate, so I apologize for that, but I think I was told I had 20 minutes. So the basis for disciplinary action, and there are a couple of sections in RCW, that's primarily 1804, 295. And if you look at WAC 43142, that's what I like to refer to as the laundry list of all the things and ways the CPAs can make mistakes. And that's a really good thing for board members to take a look at, because it is rather an encompassing universe of things that can go on. Things like, violation of the Public Accountancy Act, violation of the rules, professional conduct. And we do sort of incorporate the ICB rules of professional conduct, by reference in our WAC. We don't incorporate it completely. Fraud or deceit in obtaining a license or in filings with the board. Dishonesty, fraud, or negligence of licensed certificate holder or non-licensee owner of licensed firm. Next slide, please. Conviction of a crime or act constituting a crime under state or federal law. And I will say about this, and Bruce is able to comment on this, there is a specific case law in Washington State wherein the crime or conviction of a crime has to really be related to public accountancy or the profession that you're in. I can get into that a little bit more later on. Disciplinary actions under other. Go ahead, Bruce.
Yeah, I'll just that is a problematic area sometimes to get your hand around it. There was a case years ago of a CPA who went out boating and got intoxicated, and then got in his car and drove along Bothell Way Northwest and ran off the road and killed a pedestrian who was sitting by the side of the road. And discipline charges were brought against him by the board, and the question became, was that related to the practice of accountancy? That's probably kind of an extreme example, but it just sort of illustrates that point to be aware of.
Did you want to discuss Ritter versus Warbles?
I don't think at this for this purposes, but the other thing I wanted to say was typically when there's charges pending against someone and they haven't been convicted yet, the staff will wait until the conviction is complete, because it's much easier to prove a case with a certified copy of a court order than to try to actually prove the elements of the crime in a board hearing, which really has never been, I don't think, attempted. So that's one nuance that all the rules allow potential.
Okay. And so we had some other things too, disciplinary actions by other jurisdictions, and that's something we always have to take a look at to determine whether we feel we need to pile on. If it affects, people in Washington State, if it, like an audit, for instance, if it, companies that are headquartered in Washington State, or even Washington State, stockholders, in the case of an audit or anything else, we kind of weigh whether that's something we need to do, and that's where the CBM comes in. suspension or revocation of right to practice public accounting before a state or federal agency. Any federal disciplinary issues that come into play are something that the board can consider, and often those are prima facie evidence that we can use to employ discipline against a person licensed in Washington State and not maintaining qualifications for licensure. Next slide, please. Failure to respond to board subpoenas, failure to cooperate with board investigation, failure by a non-licensee owner of a licensed firm to comply with the Accountancy Act and rules. We get people that just don't respond. Oftentimes that just results in a default hearing, and that is relatively simple, although they do have the right to appeal that also within a certain amount of time, is my understanding. Failure to comply with the board orders. Sometimes we hammer out these consent agreements, and the people do not abide by them, and that is the basis for possibly imposing a state suspension. False advertising is one that comes up. You can't make claims that are not valid or that you can't support under our RCW, and also in our WAC we have information, but a restriction against that as well. Next slide, please. Unlicensed practice, use the CPA title. We do get these people from time to time that either they don't understand, they can't use the CPA title without being licensed in Washington State, or at some point they took a test and they treat it like a high school diploma, which is not the same thing. And they'll use a CPA title, and that can be kind of contentious. Late renewal or non-renewal of a CPA license, is also problematic if they're continuing to practice in public accounting. Continue, please. Prosecution team members, we have an executive director, staffed by myself at the moment. We have investigation staff, Taylor, Kelly Wolficle, and Jen also will participate as the deputy director in evaluating cases. We try to get as many eyes on this stuff within the staff as possible before we even take it to a consulting board member. But once the report is drafted, we do involve a consulting board member so that the board has a role to play in the prosecutorial side as well. If a person is recruited as a consulting board member for a particular case, they no longer have the ability to vote on that particular order, and they have to, recuse themselves from the, approving the final discipline that's, the consent agreement if it's agreed upon with the respondent. We also have our prosecuting assistant attorney general, Elizabeth Lagerberg, at the present time. Is a valuable asset when we're trying to look at what we're going to do with a particular case. So some of these things get into some really tight legal issues that we need to make sure that we're moving forward with correctly. And, it's a mistake to not use the attorney when you need them in a particular situation. I would like to say anything about the consulting board member. Access to these cases or their involvement has increased under my administration of being executive director. I think it's very important we have board involvement in every case, and every case at some point is reviewed by a board member, even the cases where it's a clear lack of jurisdiction. I want to make sure that a board member sees everyone. Next slide, please. Complaint process. The investigative team reviews all complaints to determine if allegations are within the board's authority, and an executive director may dismiss, but again, or assign to an investigator depending on what's going on. But even in the case of dismissal, the board has the opportunity, or CBM is involved with that particular case to see if there's anything about that might give them pause to reconsider that action. Next slide, please. There's no jurisdiction. We do dismiss a case. There's no jurisdiction. There's no not within the board's authority. Like somebody's not maybe they're a tax preparer. We had a lot of complaints against tax preparers, or we did at least until our process was improved. Taylor did quite a bit of work on shunting people through the complaint process so that they become aware that if they're not a licensed CPA, we don't have any authority to investigate them. There's no basis for investigation. Sometimes you just get these complaints that are, my CPA was not acting appropriately, or maybe they used a bad word or something. Sometimes that conduct can come under jurisdiction, but oftentimes these are just disagreements that people have with people that we don't have any authority over, or exempt from investigation by board policy. And the biggest example of that is fee disputes. We close the file, we notify the complainant that the board will not be investigating, and also, the respondent as well is aware of that, so they can request a copy of the complaint if they want to. Next slide, please. Investigations are conducted under 43140 WAC. We just recently revised that WAC quite a bit to kind of really clarify what the investigation process is. Complainant is notified in writing. The complaint will be investigated. Lead investigator handles the investigation. And, it's one thing as executive director, I'm really not as closely involved with. There is some merit to the idea, as Bruce has explained to me, that it's nice to have the executive director sort of outside of the investigative process so they can be an objective reviewer of the complaint when it comes in. And that's where, we'll meet often once the investigation is fleshed out with the investigation team and hammer out some issues. And those are good discussions. That's probably the most interesting part of the job when it gets to disciplinary work, that you really get everyone's opinions, and there can be some widely divergent ideas about what has happened in a particular situation. Copy of the complaint then goes to the respondent. In most cases, a response requested. And then we just, want to make sure they have the opportunity to respond to this and get their perspective on it, and you do. And then we determine an investigative plan to kind of see where we're going. And we do, like I said, there's a lot of work done on these things before the report is even completed. Next slide, please. Okay, once the report comes to the executive director, and I think this this section of the slide needs to be updated because we do bring the ED in a little sooner these days to look at, it depends on the case. That there is a lot of things happening. We have kind of a high stakes thing going on now where the consulting board member was brought in rather early to kind of get a real perspective and to add that board input into the issue that had evolved. And so I think that's very valuable. We don't do that all the time, but most of the time it does wait until the report is completed. And then that's when the CBM comes in, but not exclusively. Anytime the ED and the CBM determine insufficient evidence, the ED may dismiss the complaint and close the file without further action. Please continue. Next slide, please. Most investigative actions for some time, for some first-time violations, we do have an administrative authority now, but this has changed quite a bit because a lot of that had to do with CP deficiencies, and we have changed a lot of how we're doing that. We'll have a little presentation later on today to discuss that, but in some cases we do have some... Go ahead. Okay. We do have some things that are... the board has allowed the ED to take care of administratively, and I'd like to refer to these as sort of traffic ticket types of issues. For other violations with CBM concurrence, we serve a statement of charges, and we do that. We do serve a statement of charges now every single time, and that was at the behest of our Assistant Attorney General Elizabeth Lagerberg, and Bruce has weighed in on this as well, that we want to make sure the respondent really knows what their rights are. As I've been told, that my job is not only to ensure the rights of the complainant, but to ensure the rights of the respondent as well, to make sure that everything is, all their options are vetted for them.
Charles, could you explain a little bit more to people that, they get served a statement of charges now and a consent agreement?
Correct, yes.
Those two documents a little bit more.
Yes, there are two things that happen. The statement of charges will go out concurrently with a proposed consent agreement. So there are two things. Thank you, Mark. That's very helpful. So they can see their options. The main thing about the statement of charge document is it does lay out all of their options for a hearing, so they realize that, if they're accepting a consent agreement, their right to a hearing is forfeit. And, if they want to go to a hearing, they're going to be heard, and they have some other options. Even after if the board issues an order, they would have some appeal options after that point. And they go with a consent agreement, that doesn't really exist, but most of the time we try to sweeten the deal a little bit with a consent agreement to, facilitate, a negotiated settlement. And that's really, we have been successful at that by and large. We haven't really had very many hearings except for default hearings recently. We try to make sure the disciplinary process is kept up in a timely manner. When I first became a director of investigation, we had quite a serious backlog of cases, and that has since been cleared up, and I want to keep it that way. Next slide, please. The adjudicator process, and now I will turn this over to Bruce.
All right, and I'm not turning my camera on only because when I tried that at the outset of this, I was kicked out of the program altogether and had to come back in, so I'm afraid to turn the camera on. So next slide. First, before we talk about the formal adjudicative process, I wanted to explain screening, which I think you've already heard about, but there's a prosecution team, and Charles has talked about that. That's the board staff involved in the case, or all the board staff really, except probably Kirsten, who serves as the board clerk. The consulting board member, who's tasked with that, helping that particular case, and Elizabeth Lagerberg is the prosecuting AAG. And they may not discuss the case with other board members or me as the AAG advisor, or Michelle as the incoming AAG advisor, and vice versa. And that's to avoid any ex-parte contact, in other words, discussion of the substance of the case outside of a hearing context where the respondent is entitled to be present. However, these two sides may discuss procedural status, like do we have a hearing scheduled on such and such a date, and confirm things like that. Next slide. So statements of charges, as was already discussed, are sent out. The practice is to send them with proposed settlement agreements called consent agreements, and sometimes I guess they're maybe even offered before statements of charges are served. I'm not sure if that's still ever done. But the executive director may issue a statement of charges which begins the formal hearing process, which is under the State Administrative Procedure Act, which provides the sort of due process structure for how administrative hearings are to be conducted. The respondent has the opportunity to answer the statement of charges within a stated time period and request a formal hearing. Next slide. So consent agreements, as Charles said, are alternative to a formal hearing. They would preclude the opportunity to have the hearing. And the board policy encourages, in fact, the Administrative Procedure Act and state policy itself encourages negotiated settlements. Their results, of course, are much faster. It saves a lot of board resources. It saves your time of scheduling a full day for a hearing. And it's thought that it enhances compliance. If someone's agreed to pay a fine, that they're maybe more likely to pay it in a timely way than if they're ordered to pay a fine. And they actually, settlements may be reached at any time in a case just because a hearing's been scheduled, or it's the eve of the hearing. It's not too late to settle a case. And that sort of thing has sometimes happened, and I've always felt getting a hearing scheduled sometimes motivates people to settle their cases, which they may have been, putting off and kind of maybe even in denial about. So there's an advantage to moving ahead with the formal process in a lot of cases where there's sort of a lack of response. And sometimes they do end up, as Charles mentioned, in default situations, which is where the person doesn't show up for a scheduled hearing conference or doesn't show up even for a hearing where everybody's assembled. And then the board just goes ahead and issues an order and decides on the sanction. And next slide. So this is a continuation of discussion of consent agreements. So the initial terms are identified by the executive director in consultation with the consulting board member. They have a lot of flexibility and discretion in customizing sanctions and terms of resolving a case. And they may be self-enforcing, such as state suspensions. There are suspensions of licenses that are stayed based on compliance with conditions that the staff can craft, and so that's quite a strong motivator to do remedial coursework and do a number of things, pay fines and so forth in order to maintain your license and keep that suspension from being imposed. Next slide. So they may involve a settlement conference, they may involve